Number 1, Town of Southampton versus DEC. Counsel?
Good afternoon, Your Honors. If it please the court, my name is Gregory Brown. I'm for Appellants Sandland Corporation and Wainscott Sand and Gravel Corp. If I could reserve 5 minutes for rebuttal, please.
You have 5 minutes.
Thank you, Your Honor. Justice Pritzker had it right in his dissent when he said that an application for a permit to mine is not the same thing as any mining application. A mining application can be a renewal application, a modification application. But an application for a permit to mine is defined within the Mine Land Reclamation Law, and it was done so through the 1991 amendments. It had previously appeared as a term, but the 1991 amendments helped clarify exactly what that was. And the key to doing that...
Can I ask you, I believe Justice Pritzker's rationale or justification for that reading had to do with avoiding a constitutional defect in what he perceived as or a perceived constitutional defect in the majority's reading of the section. Is that the way you view it?
That's also the way, yes, Justice Pritzker pointed out that reading it that way would create a constitutional problem. However, the statute itself provides what is a permit to mine, which doesn't create any constitutional issue at all when it's applied according to its language. Because a permit to mine is defined by the various provisions that were adopted in 1991. So like the Mine Land Reclamation Law changed the definitions for what has to be included in a mining plan. And so what has to be included in a mining plan is a graphic description, proposed mining operation, including the boundaries of the land controlled by the applicant. The definition of a permittee was also modified in 1991.
But under 700105, isn't the definition of permit, doesn't it include a modification or renewal?
The definition of a permit?
Yes.
Yes, but the definition of the permittee, this is why it's so important, is because it's limited, it specifically goes to the boundaries of the land identified in the mine land use permit. So when the permittee goes in, consider this a new permit. They go in with a new application. The mine land use plan is a key document here. It defines the boundaries of the mine site. In this case, it's been 50 acres for decades, but that's the property boundaries of the mine site. Once that's defined, then 27033 works well with 2711, because then a permit to mine is only when it's either establishing the new boundaries of a new mine or it's a mining application for property not previously permitted. And that way, a permit to mine, it captures both the property as it exists when it was first permitted and if there's a modification application to expand it to add additional properties.
But not a renewal.
But not a renewal, just a straight renewal or any modification that didn't seek to change the property boundaries of the mine.
So depth wouldn't be...
No, depth wouldn't have anything to do with it.
But isn't another way to avoid the constitutional problem just to factor in nonconforming use? Right, so you have a pre-existing nonconforming use. So the village says that. This seems then to be a fight over the scope of that pre-existing.
Yes, so the second part of the language that was disputed was if the local zoning laws or ordinances prohibit mining uses within the area proposed to be mined. And the question was, well, if you also were including it within the zoning law, which I think you should, the parts of the zoning law that say is non-conforming use is allowed, then you would also not reach a constitutional
So the problem there would be an overly restrictive reading of the term zoning law, either by DEC or the appellate division in this case.
Yes, Your Honor. And I think it's just not reading the statute correctly, because the statute says
I'm
the
sorry,
area
isn't
proposed...
the problem more the scope of your pre-existing non-conforming use? I mean, isn't that what you're then fighting about? Because you want to go to whatever feet down, and they're saying, no, you were only allowed to go to a certain depth.
Yeah, I mean, this provision doesn't speak to prior non-conforming use. It doesn't speak to land use. This provision doesn't change anything with local law. It's not about changing local law or enforcing local law. It's about what the agency is telling the agency, you cannot proceed until some issue on land use is determined. So what if the agency
asks the town and the locality, and they say, no, this is beyond the scope of their pre-existing use? Then they don't process it. You go to the town and you say, we don't agree with that, and you can appeal their zoning decision.
Yeah, so that could happen a couple of ways, Your Honor. So it's like for upstate, where it's clearly, so the law applies any place where there's a sole source aquifer and a population of more than 1 million. Okay, well, there's quite a few sole source aquifers designated under the Safe Drinking Water Act in the state, but only 2 counties that have more than 1 million at this point, from upstate. So the statute could be applied in more than one area of the state. But if you get to upstate, the way it's applied is DEC has to still continue to process the permit because the permit doesn't change local zoning. It doesn't have any impact. The town can still enforce it. But that doesn't slow DEC down from its UPA obligations, SAP obligations to process the permit. So if it applies and it's in the county, then it'd be like the Valley situation, Valley Realty situation, where say it was a new permit and there was an argument about prior non-conforming use. If you consider that prior non-conforming use, then DEC wouldn't be able to continue to process that permit. It would just have to be determined. And the question is, well, DEC...
So are you saying that DEC normally doesn't consider whether there's a pre-existing non-conforming use, or that they traditionally do?
Well, when they first adopted their guidance document, they weren't considering prior non-conforming use. They looked straight at, okay, what's the zoning district say? And in the Valley case, they actually argued we don't have to consider prior non-conforming use and whether to continue to move forward with an application where the permittee says, well, is it permitted at this location? All right, that's how it came up. And the court said, no, you have to also consider prior non-conforming use. So
outside of Nassau and Suffolk, if these were the facts and there was this disagreement, but you get the permit, what could the municipality do at that point? Now you have a permit, but they think this is a non-conforming use.
Then they can go ahead and bring enforcement action. It could be a ZBA action. I mean, there are other issues going on with the site about other uses.
But they'd have to go in and get you to stop doing what you're doing and while they do that, right?
They would either have to stop or there'd be a dispute. I mean, it could go to the zone, we could ask for a ZBA determination. I mean, that actually happened in the first part, in the very early part of this case, in 62. The very first way it came up was the code enforcement officer said, this district doesn't allow zoning. And there was a decision by the ZBA at that time that it did allow mining.
But it seems to me like if you say this applies here, this provision, that's the purpose of this was to make it the burden of the mining company than to straighten out that non-conforming use, and not the burden on the municipality to try to stop you once you got a permit from DC.
I think to stop you, stop them
from mining in a way that they think violates their zoning laws.
Right. Well, I think it's more to stop them from having to participate in seeker in all the hearings to go through that process, which requires experts, lawyers. You know, before a permit, they don't ever think they're going to ever allow.
But the way this case was litigated, the way the Supreme Court sort of just said renewals are not part of this process, and the completely contrary ruling at the appellate division removed that whole process. The municipality and the mining company haven't had a chance to litigate the applicability of the pre-existing non-conforming use. That process that you just discussed with Judge Garcia never took place here.
That process has taken place over years with the initial certificate of occupancy issued that made that determination, a ZBA determination, court cases going up to the second.
But those are on prior renewals. That's not on the latest permit, because the latest permit was just issued as a result of a settlement negotiation.
Right. But you wouldn't determine prior non-conforming use every time you got a new mining permit. That's what that would be, because this...
It is if you're changing the terms of what you want to do.
You have more horizontal area and deeper vertical. You're saying there's no opportunity in that scenario to talk about whether or not the prior non-conforming use permits that kind of change?
Not within the DEC permitting process.
No, I'm talking about litigating it at the town, at the municipality level, which didn't happen here.
The town actually has there is enforcement action by the town. The town has said we're going to not pursue that as to the mining part until this decision is done. But The town has plenty of opportunity to enforce its laws. The mine land reclamation law doesn't affect that. It doesn't prevent them from going forward in any way.
The scope of a prior non-conforming use could be determined horizontally, right? That is, this many acres you can mine, right?
Well, it wouldn't be a dispute within the mine land reclamation law, but the dispute as to if they,
Right, but if we're
they
trying
wanted
to
say our
determine, if we're
scope
trying
of
to determine what
non-conforming
the
use is
scope
less than the
of your prior
property.
non-conforming use is, I mean, we have case law about this, right? It isn't necessarily what you've mined to date. If you had a reasonable expectation of mining additional property going horizontally, right, that might be within the prior non-conforming use, right?
One would expect so,
And
because that's how the mine
ba-
is
but there
developed
might be-
originally.
But there might be limits to that. That is, there might be property that's adjacent that you own but had no intention of mining, and if that's how the facts laid out, you would not be able to claim that as a prior non-conforming use horizontally.
Correct,
With
Your
me so far? So why isn't there a similar kind of rule that would apply vertically? Let me put that differently. Are you saying that if you were able to mine a particular acre, let's say, and that's a prior non-conforming use, you can mine it as deep as you want regardless of what the facts show about your intent to mine at the time?
Well, it's interesting, Your Honor, because the intent, when people go to apply for mining permits, and it shows this in the record in the very first application, what they designated they wanted was, we want those mineral reserves. There's sand, there's loam, that's what we're getting, the mineral reserves. That's what they acquired the property rights to. They didn't say, we want only some of those mineral reserves. We only want part of those mineral reserves. We want the mineral reserves on that property. That's their inventory.
Well,
no,
to Judge
no.
Wilson's question, though, wouldn't the secret process limit if the DEC had determined in this case that going to 120 feet above mean sea level would somehow negatively impact the aquifer, that would have impeded the permit, would it not?
Then that would have, on the seeker grounds, on the basis of
Yes.
seeker, they would have been able to condition the permit and say, no, you can't go there.
But they actually didn't want to get all the minerals on the 50 acres. They only wanted it on the 31 or whatever it is acres, 34, right?
Well,
So there was a horizontal limit. They weren't saying, I want all the minerals on the property. It was limited horizontally, no?
well, what determines the limit going down is actually the size of the property itself, because you need a setback from the property line.
Well, is
And
it,
you need to maintain certain slopes for safety, so you
Is
could
it-
only go so deep.
so
based on
it's
the-
not a statement of what they intended to mine. That is, if they said, we intend to mine 60 feet below grade, that couldn't constrain, and let's say it's technically feasible, based on what you're saying, to go to 500 feet, or maybe all the way to China. If they said, all we intend to get is 60 feet from grade level, that doesn't constrain them, because it's technically feasible to go lower.
It's technically feasible to go lower.
And therefore, it doesn't matter what they said about their expectation at the time.
Well, when they apply for a mining permit, the mining permit itself isn't the definition of whether or not they have a prior non-conforming use under this court's precedent. You can establish a prior non-conforming use with a mining without actually obtaining a mining permit.
All right, so let me try a variation then. Suppose at the time they acquired the property, technology only allowed you to go down 100 feet. And in the, whatever it is, 80 years since then, technology now allows you to go down 200 feet. Does the expectation at the time limit their property right?
Well, the expectation at the time is to take the minerals that they can get from that property.
At the time?
At the
Or in
time
the
they
future?
acquired the
Or in the
property.
future?
Or in the future. But it's just the nature of mining. When they first started this mine, it was a 3-acre mine. And they originally had I think the original application said we're going to affect half-acre a year. Then it became, the affected area became larger. That's the definition of affected area. It's expected to change over the course of the mine's development. So there's nothing in the mine land reclamation law that says, that determines prior non-conforming use. I mean, it is determined by the facts of the property.
So it's an evolving type of thing with respect to how far or what they can do?
Well, of course, precedent has been that once a property is devoted to mining use, that the expectation is that the corpus of the land will be used up.
So they can use
that
it
use.
until the maximum potential of its useful life is over?
Yes, consistent with other restrictions on use. such as...
So there can be other restrictions still?
Sure. Yeah, it's like the State Environmental Quality Review Act, which could end up requiring restrictions and limitations on the mine.
Thank you, counsel.
Thank you, sir.
Good afternoon, Your Honors. May it please the Court, my name is David Arnson of the firm of Voles & Vigliotta. Excuse me. I represent the town of Southampton here this afternoon. I think Your Honors have touched upon the issues that we think are determinative of this appeal already. The state statute 23-27033 was clearly enacted by the legislature with a purpose in mind, which was to change the processing of permits for mine expansions, particularly on Long Island, and particularly because there is a sole source aquifer that provides clean drinking water for Long Island.
So when you say expansions, what if it was simply a renewal, but without expansion?
I think, Your Honor, the way that plays out, to answer your question, is in a renewal application that's a strict and straight renewal, as happened on this property for several years. There were renewals on this property without any litigation or any contention going back to right about the time that the mine land reclamation law was amended. With a straight renewal, the way the guidance of the DEC at the time it was enacted was written was that the process would be DEC writes a letter indicating to the town they're going to be the lead agency for secret purposes. And in conjunction with that letter, a letter on Long Island goes to the chief administrative officer and asks whether there is a local prohibition on mining in the area proposed to be mined. That comports specifically with the statute. Where Long Island differs from upstate, the other 60 counties, is that while the hashing out of whether there is a prohibition on mining under local law, DEC must stop the processing on Long Island.
But what's, to Judge Wilson's question, what's the answer to his question? I mean, is that okay or is that not okay? If it's the exact same renewal, the exact same terms for the renewal?
Yes, Your Honor. I think if the question still must be asked, but the answer would be, it's a non-conforming use, it's the same land, it's the same sand.
But that doesn't seem to be what the appellate division said. Go ahead.
Your Honor, I think what the appellate division said, and it's towards the end of the decision, is that the application is to be put on hold. Any application, Your Honor, is subject to the process.
So let me ask you this. What would Southampton have said if this had been simply a renewal without any further expansion? Or do you know?
I don't know in this particular application what they would have said, although I can answer what I think they would have said. But I can answer that since 1991, there have been 4 or 5 renewals without any objection by the town. So I don't think as a matter of
Do you know whether that is because the town believed that a renewal without expansion is a prior non-conforming use that is constitutionally protected?
Your Honor, I suspect it's because the DEC never asked the question and that the renewals were just given. But I also think that the municipality, the town would have said, this is the same area that was previously permitted, the same reserves, the same boundaries. It's essentially a ministerial act.
Well, the town did provide declarations saying that they had allowed mining as a prior non-conforming use during previous permit renewals, hadn't they?
Yes, Your Honor.
So it's not exactly the same as saying they didn't challenge it. They acknowledged that there was a prior non-conforming use in place, and the implication being that they understood that that would be permitted under the statutory regime at the time.
I think that's correct, Your Honor. But the question becomes on the current application, the one that brought all the litigation, is this is no longer a straight renewal. From the beginning, the mine sought a lateral expansion of 4 acres and a depth expansion over the 31.5 acres of 40 feet, a severe modification of the existing permit.
So let's say they disagree with the town on that. They think this is within the scope of their prior non-conforming. What's their recourse?
Their recourse, and they actually utilized it in this case, was to commence in Article 78. That's one option against the town, saying that the town's declaration that mining was not in conformity with local zoning is in error.
They did that?
They filed an Article 78.
They filed that Article 78?
But at the time of the filing of that petition, the administrative matter was still pending. This case was still pending. The appellate division decision had been rendered, but this court had not yet decided it was going to take the case. And so it was dismissed by the trial court as being not ripe for review, because it could not be determined on that record if an actual injury had occurred based upon the town's position. So there are remedies at law available. In this particular instance, this statute provides a procedural guidepost for the DEC. What it is saying is, we recognize that sole source aquifer is critical to the drinking water. We want to put in place a way to be sure, before DEC entangles itself with the process, that there are no local prohibitions. And DEC understood this from the get-go, because they would send, at least their guidance suggested they should send, letters to the chief administrative officer saying, are there local prohibitions? And DEC at that point, if the answer was affirmative.
But does that same argument make the same sense when you're talking about a renewal as opposed to a new application?
Your Honor, I think when it comes to a renewal application, the presumption would be, if it is a pure renewal, and again, in this record, there was never a pure renewal application. But if it was a pure renewal application, it would be agreed upon by the municipality, presumptively, that this is just an extension of time. That's really what it is. It's extending the term, but it's not changing the mining.
So would you agree, if we agree with the third department, does all mining on Long Island stop?
Absolutely not, Your Honor, because as the third department held, what happens is the application is put on hold. It's not stopped. It's put on hold until the local prohibition issue is addressed. And there are, as we've said before, there are remedies to the mine and the municipality to figure it out. In fact, in this case.
So in that instance, they can't do what they were already doing before the application was submitted, the new application?
If there was a wrongful determination by the municipality and the applicant believed that determination was wrongful, then the applicant would have the right to immediately seek judicial review of that determination. Because if the municipality is wrong, and they have the right, it's just a rubber stamp, and it's speculative to say why that might happen, but I suppose it could, Your Honor, then in that case, the courts would be the remedy for that. But in this case, the initial application, even the revised one that arose as a result of the settlement, was not a renewal application. This case, the DEC styled the post-stipulation application as a renewal, but there were 3 extra acres added to that permit. And when questioned about it, DEC's position was, this is a ministerial error. It was a typo.
Let's say we had not granted leave to appeal. You have the appellate division decision. What recourse would you have? And I mean, I'm sorry, let's say it goes the other way. You lose, the town loses. Mm-hmm. What recourse would the town have? Do they have this permit now? Can they go mine to whatever depth they are
well, Your
permitted
Honor,
to?
on that subject, I would say that presupposition, which is what I think the appellants want this court to endorse, is that it's presupposed that with a mine you have unlimited depth rights.
My question is procedurally, is there anything that the town municipality can do to stop the mining from going forward at that point? They have a permit, but your view is they don't have authority under the zoning laws to do what they want to do.
If the town believes that the DEC's act of permitting was done in error, as the town did in this case, they filed a petition, an Article 78 against the DEC, saying it was arbitrary and capricious of them to issue that permit in the face of a local.
My bottom line question is, once you have the permit, and let's say the permit is upheld, can they go mine, or does the town have any recourse in terms of enforcement of their zoning laws?
I think the town would have recourse, and the reason for that is that the DEC permit is not a land use permit. Right. It's an administrative permit. If the town believed rightfully that they were superseding, going beyond their pre-existing non-conforming use, and therefore were in violation of the land use, the zoning laws, the town could bring an action to try to shut the mine down for being in violation of the zoning code.
Thank you.
Thank you.
Thank you, Your Honors.
I think maybe the main point I should make, although maybe it's already been made pretty adequately, is that the questions that imply that the central issue here is whether there's a non-conforming use or not. that is the ultimate issue that has to be resolved. Of course, that's right. Of course, if there is a constitutionally protected nonconforming use, neither this statute nor anything else can override the Constitution. Nobody's really disputing that. However, Sandland has chosen to litigate this case not as a takings case. Indeed, they say in one of their briefs, this isn't a takings case, this is a statutory interpretation case. I think the reason my personal opinion is the reason they're saying that is they know they lose the takings case. But in any event, what they say is, no, this is a statutory interpretation case, and you have to interpret the statute in this funny way, that it does not apply to anything except a completely new mine. It doesn't apply to a change of a permit on an existing mine, whether it's constitutionally protected or not. That is a totally untenable view of this statute. It is, and perhaps the best evidence of how untenable it is apart from the text of the statute, there is also the obvious purpose of the statute, which Sandland is at such great pains to avoid. Sandland tells you 3 or 4 times in its briefs that there's no reason to think that the legislature had any concern with protecting the aquifer against mining. But if you read the text of the statute says that the DEC may not process a permit to mine where a local zoning ordinance prohibits mining within counties with a population of 1 million or more, which draw their primary source of drinking water for a majority of county residents from a designated sole source aquifer. How is it even possible to think that they would think about the aquifer?
It seems very obvious to me that the legislative policy here was to protect the aquifer. I will not debate you on that. The problem is, looking at the legislative history, they don't seem to be cognizant when they enacted this of any limitation that might be imposed by the due process takings part, the pre-existing non-conforming use.
Well, whether they expressed it or not, they certainly they have to be deemed to be cognizant of it, and you do have to read the statute exactly the way Judge Garcia suggested a few minutes ago, as to say if the local zoning prohibits mining, you have to read into that the local zoning it can't prohibit mining where you've got a constitutionally protected use.
So where do they litigate the scope of that prior non-conforming use?
I think Mr. Arnson's right on that if there's a bona fide litigation, which I have some doubt there is here, but if there's a real bona fide dispute about non-conforming use, it does seem to be that the DEC doesn't have to decide that. The DEC doesn't want to decide it. It winds up in court. Indeed, that's not just what I say, not just what Mr. Arnson says. It's what Sandland's amicus says very clearly. The Materials, whatever their name is, Materials Manufacturing Association of Long Island, New York Construction Materials Association.
That sounds right to me. But the problem at the end of the day is the appellate division decision here, which doesn't explicitly say so, but seems to very strongly imply that whether it's a renewal, a modification, or a new permit, if the local zoning for that district doesn't include mining, that's it. The question is over.
Well, I guess my answer is I don't think that's what the appellate division intended to say. If they did, I think this is an opportunity for your honors to clarify it. But the result the appellate division reached was right here. The permit can't issue.
So what is the venue for litigating the scope of the prior non-conforming use? Because there seems 2 options, right?
Yeah.
The DEC can stop processing and they can go and bring an action against the municipality, or the DEC can give them a permit and then the municipality can try to stop them from mining. So why would we do one or the other?
It depends what county you're in. If you're in 60 counties of the state...
But we're in the county we're in now.
If you're in Albany...
No. You're in the county in this case.
But if you're in Suffolk County, that's what the statute says. The DEC stops, and the burden is on the mining company to try to get its permit.
What if the county comes in and says, and this is a straight renewal for the same terms as before, the prior non-conforming use, and the county says, no, but our zoning laws don't allow mining in Suffolk County and in our town. But they have a prior non-conforming use, so DEC has to stop that, and then they have to go back and litigate against them?
You're putting an unlikely case that has never happened, but I think probably the correct reading is yes, That is, you're talking about a case where the town makes the rather strange claim that I have the right to completely shut down what they've been doing. Maybe they have a reason. If they have a reason.
Maybe they read the appellate division decision.
Yeah. Again, I read the appellate division a little more kindly than you do. But if the town takes an outrageous, you say what happens if the town takes an outrageous position? They have no basis for saying that they're entitled to shut it down, and they say we are entitled to shut it down. Then the litigation happens fast. But I think even there, the burden of bringing the litigation is on the mining company. And again, I do want to quote an amicus that they think is their amicus, but I think is my amicus, the New York Construction Materials Association. Quote, for Long Island mines, if the municipality claims that their local land use laws prohibit mining, DEC is prohibited from processing the mining application unless and until the local dispute is settled. And that, if you assume generously that there's a bona fide dispute here about nonconforming use, that describes this case. And now somehow the amicus managed to put at the end of its brief, and therefore the order should be reversed and Supreme Court reinstated. I have no idea how they got there. But the sentence I just read you said absolutely unequivocally, and that's their amicus, says the DEC is prohibited from processing the mining application. And that's all there is to it. I think one of the things that complicates this case, as I said at the beginning, is that this is really this should be a dispute about nonconforming use, and Sandland doesn't want to have that argument because it doesn't win that argument. It wants to sell an interpretation of the statute based on the premise that the statute has nothing to do with protecting the aquifer, which is a ridiculous
Can I offer you an
premise.
alternative view? Because I don't want to prejudge the prior nonconforming use issue either. But in this case, when the ALJ said we need to follow the process and refer the question to the town responded quite simply that our local zoning for this area does not permit mining, period. And nothing else. And that is different than what they did during previous renewals when they did advise that they had issued certificates permitting the mining because it was a non-conforming use. And it seems to me, you postulated a moment ago that the town wasn't really trying to stop them from just doing a simple renewal, but it seems to me that maybe they were because they didn't include that extra piece of information this time when the inquiry was made.
Well, see, I'm not absolutely clear on your question. As I understand it, all the previous straight renewals had just happened. It's not even clear to me that the DEC asked the question, although they are supposed to ask the question.
I think the town had previously sent declarations that they had given prior non-conforming use permission.
Yeah, they've never disputed there was a non-conforming use, as far as I know. And
but this time they didn't. They just said the local zoning ordinance doesn't allow it, and that's different.
Well, I think they may have been they may have been answering the question in literal terms, but again, I have to get you. I think you have to give Judge Garcia's gloss even on that. When we say that our local zoning ordinance doesn't allow, parenthesis, we do allow non-conforming uses, but it doesn't allow mining when it's not a non-conforming use, and this isn't. Okay, they could have said it. They could have said it more clearly.
And they really tracked the statutory language, right? Local zoning laws prohibit this.
Yes, but as I say, I think the statutory language has to be read with the constitutional caveat that Your Honor suggested earlier.
Okay, thank you. Counsel?
Both of my adversaries have pointed to some suggestion of not wanting to have an argument about prior non-conforming use, avoiding that issue. I think it's important to understand the record here of what is the expansion of the mine that is within that renewal. It's an area of 3.1 acres that was mined prior to the very first permit, mine land reclamation law permit. It had already been mined to the same depth as what the proposed depth is that is under the modification of 110 feet.
But let's say they claim this is a prior non-conforming use and they respond that way. I know Judge Canataro accurately said what was in the record here, but is it really for DEC to determine what's the scope of the prior non-conforming use? I mean, isn't that really a local zoning issue? So why would that go into this DEC process at all? Why isn't that a fight you have with them on a zoning basis?
Well, I think there's other things that also are at play here, which is that the Uniform Procedures Act and the Mineland Reclamation Law both envision that people will be able to apply for permits for the orderly development of resources, and that there's time limits on the DEC processing those permits and moving
But they changed that for
forward.
Nassau and Suffolk. I mean, they made them different for a reason. And so it seems that this fight over the scope of a prior non-conforming use is misplaced to me in a way. Why isn't that a zoning issue? And then you can litigate the zoning determination.
Well, I think that Your Honor is correct. It is a zoning issue. We could litigate that zoning issue, so could the town do that. The question is really under this statute is, can we proceed with our permit? Will we be, like for a renewal, will we be able to continue mining, or do we get stopped because the town says, no, that 3.1 acres that you mined before getting your permit, that's an expansion of your prior non-conforming use, so you have to stop mining.
Well, you might win or lose that in court.
But that's certainly harmful to a business we have to wait for that determination in order to get our renewal permit.
Under the
What is it?
statute, could they give you a permit to mine to the extent you're already mining while you litigate it? I don't know the answer to that. Is that possible?
Well, that's another oddity of it, is that under the State Administrative Procedures Act, we can apply for a renewal, and you can operate under that renewal indefinitely until such time as DEC processes the renewal.
Mm-hmm.
So we can get a renewal even though DEC, under SAPA, even though DEC is not supposed to process or complete an application for renewal. So DEC would then be in the odd position of not being able to actually look at the application and say, is this a sufficient application for under SAPA? Because they would be processing the permit. Right? The renewal just doesn't fit in the statute. Right? And the reason it doesn't fit is because the statute uses defined terms in order to exclude certain types of permits, to only exclude those permits that expand the boundaries of the property, either initially define the boundaries of that property or expand the boundaries of that property. With that, Your Honor, if there are no further questions.
Thank you, counsel.
Thank you.
Thank you, everyone.